Hello, everybody. Thanks for tuning in. Today, we've got the pleasure of having Steve Silverstein. He's an eviction attorney in Orange County. I've referred many clients to him. If you have a tenant that needs to be evicted, he is the guy to go to. Those of you that have not subscribed yet, please click on that subscribe button. It'll help get this video out to more and more people. What kind of leverage does a landlord have with a tenant? A landlord could go in and, should I say, ruin their credit, or they could put a ding on their credit. They can get a judgment at least. And then in order to get a judgment, they have to file that against the county. Is that still how it works? It's been a while since I got my broker's license.
If you get if they get an answer and you go to trial, you have the option of going to trial and getting a money judgment or getting a money judgment against them. Credit agencies pick up those judgments unless part of your negotiated settlement is where you seal the case. And a lot of times we will go ahead and seal the case. Sealing the case means that the legislature has enacted another protection for the tenant, protect the tenant's credit. So if you seal the case, it doesn't go on their credit report, and landlords, it's not open to the general public, and landlords won't know if they look to see if he's been evicted.
The tenant has the ability to seal records to where they...
Only negotiated with the landlord. The landlord only has that power to seal the case.
Oh, okay.
So, but it's a good thing if you can get them out earlier, because if what I usually do is I'll put down a provision saying, okay, we'll seal the case for you so we don't have to go to trial. And the sealing the case is provided you vacate by this date. And since I told you that it takes 4 to 8 weeks in Central Orange County or 4 to 6 weeks in Southern Orange County, we usually try to get them out in 30 days, and we'll seal the case provided you vacate and we'll waive the rent sometimes if the landlord says so. Will waive the rent provided you vacate by that date. So if they don't vacate, you can unseal the case. It goes on their credit. But it's an incentive for the tenant to get out earlier so the landlord can get his property back. So that's the most important thing, is getting the property back.
Now let's talk about deposits. You may have mentioned deposits. Now there's also new rules about deposits, right? You can, landlord can only have, tell us about deposits.
Well, the law changed at the beginning of this year. For a furnished apartment or house, it was 3 months rent worth of deposit. Unfurnished house or apartment, it would be 2 months. However, the legislature, in their infinite wisdom, has changed it to be 1 month. You can only collect, if your rent's $2,000 a month, you can only collect $2,000. Like I said, the pendulum has swung.
And more about the deposit. So maybe we can visit about a tenant that's caused damage. You have to show proof, right? You can't just arbitrarily, if you have a $2,000 deposit, keep $1,200 because you feel like it. No. You have to show, you being a landlord, have to document and have receipts for repairs. Is that fair to say?
Oh, here's the code section is 1950.5 of the California Civil Code. So if a person is, let's just hypothetically say you don't go through an eviction, the tenant gives you notice or you give the tenant notice. 2 weeks prior to the tenant leaving, you have to offer the tenant in writing an opportunity to do a pre-inspection. And at that pre-inspection, you can walk through and give them a list of apparent defects in the property so that they can remedy that so they can get their property back. If you fail to do that, then inevitably, or if they refuse to do it in writing, then you're good. If the landlord forgets to ask for that, then that can end up in small claims court, and the landlord can lose because they didn't fulfill their obligation under the code section. They have to give them an opportunity to do a walkthrough. Let's assume that they did the walkthrough, they gave them a list, and at the time the tenants move out when they're supposed to. And within 21 days, the landlord has to give a written accounting of that security deposit. The tenant is allowed reasonable wear and tear. Reasonable wear and tear is not defined. It's what a reasonable man would believe. And it depends how long they've been there and what kind of damage. For instance, if they were there for 5 years, then the landlord can't put a paint job on their back because it's reasonable wear and tear, unless they change the color of the paint in the room from white to purple. Then you can charge them for that paint job. You can charge them for cleaning. A lot of times that the tenant will leave, they don't clean their oven, or their toilet bowls look like they made chili in it, and you can go ahead and clean it, but you have to give them a bill. You have to, or you can charge for your own time, a reasonable time it would cost somebody to do it. You can always charge for cleaning the carpets. That's part of cleaning. Anything broken windows, but you got to give them a receipt. And this has got to be done within 21 days. Now, if they totally destroy the property and you can't do it in 21 days, then you have to give them a reasonable estimate within 21 days. And you have to send it to them. And then after you get your final work done afterwards, then you can go ahead and do the final accounting. That gives the landlord the opportunity to, if it's really trashed. And your security deposit of 1 month's rent, if it's really trash, is not going to cover that. So then you'll have to take them to small claims court if you can find them.
And a big thing I think that happens too is when tenants get let's say a 60 days notice, they stop paying rent. They say, "Oh, just keep my deposit," but that's kind of commingling. That's not supposed to be for rent.
The landlord is under no obligation to keep the rent. If a landlord is
to keep the deposit for the rent.
To use the deposit for the rent.
In fact, they can't, right? Or no?
They can if they want.
Oh, they can. Okay.
They can if they want, but that would be a foolish business decision because you don't know the condition of the premises when they leave. You don't know if the tenant is angry at the landlord and all of a sudden, oh, excuse me, and hits the wall with a sledgehammer and there's a big, you have to replace the drywall. You don't know if they're going to break a window. You have no idea what the condition is unless you have vision in the future. So the smart landlord would say, "I'm sorry," or they'll have a provision in the rental agreement that says you cannot use your security deposit for the last month's rent. And then if the tenant says, "Well, I'm not going to pay you, I have the security deposit," you immediately give them a 3-day notice, pay rent or quit, and file your eviction. Because unless you've done a walkthrough and you know this person is the school teacher or librarian that's not going to do something like that, then you pay your dime, you take your chances.
The landlord also add your costs and all their costs for evicting as far as if they were to go after a judgment against a tenant.
The only thing that a landlord is allowed to get in an unlawful detainer is rent to the date of possession or the date of court, attorney's fees if your rental agreement provides a provision of the rental agreement, and court costs. That's it. Damages to the property are not allowed in there, or if they breach their lease, you have to file a separate lawsuit for the unexpired term of the lease. So yeah. By the way, speaking of attorney's fees, if a landlord is smart, they will not have. There's usually a provision in all the old standard rental agreements. The prevailing party will be entitled to reasonable attorney's fees. If the landlord is smart, he'll have a cap on that. The landlord is, if there's a prevailing party and an unlawful detainer, the prevailing party is entitled to $1,000 in attorney's fees and costs. Because if you have that provision, reasonable attorney's fees, then that opens it up for the law firms that do nothing but jury trials, and they just hit you with discovery and run up everything because they have a open-ended checkbook that if they win, they can go after the landlord for. Because I've seen tenants win cases, not on my cases, but where the other side has asked for $30,000-$40,000 in attorney's fees after they do their jury trial.
See, that's counterintuitive. I would have thought that you, as a landlord, don't want to put a cap on there, but
I'm telling you, you do.
Yeah, right.
Unless they have the greatest job in the world, that they're the president of CBS or they work for Boeing Aircraft, you do it. If they work for Jack in the Box, there's probably these people might be considered judgment proof. If you don't know where they work, they're judgment proof. That means if you get a judgment, you're not going to be able to collect your money.
All right. Well, let's take it from the other side now. And I have a feeling, I don't know. We'll see what you have to say. So what rights do tenants have during an eviction process?
Oh, they have the right to live in your property until they get you out. They have the right to make sure your notice is done right, and they can ask for a jury trial. And that is leverage that the tenants have. That's the ultimate leverage, requesting a jury trial, because all of a sudden it just got expensive for the landlord. Because no unlawful detainer attorney, I do flat rates for a court trial. but no attorney is going to do a flat rate for a jury trial. All of a sudden, it's big boy law, and you have to dot your I's, cross your T's, and you have to prepare for a jury trial. It's like on TV. You get a jury, you have to pick a jury, you have to prepare jury instructions, and it gets expensive.
And that's why you want to put a cap.
That's why you want to put a cap, because that dissuades a lot of attorneys from the other side. However, it doesn't dissuade all of them, because a lot of them will go ahead and they know that their tenant is judgment proof and that it's going to cost the landlord to get them out. And they use that as leverage to extort money out of the landlord. Because at that point, and as I mentioned earlier, the landlord's going to have to make a business decision.
Yeah.
Is it worth more to pay an attorney to get a judgment that he can't collect because the person is judgment proof, meaning he doesn't work, he is illegal, and you're never going to see, or he gets paid under the table, and you're never going to see your money, or pay some money to the other side, get a result that you know is going to be enforceable. They usually say, in the old days, it was like $2,500, but now one law firm is asking $30,000. A lot of times you can settle with the attorneys for $5,000, because I ask for $8,100 up front when I have a jury trial. $1,500 for preparation for a jury trial, and $2,200 a day for a jury trial, because all of a sudden you've got my attention for the whole day, and the rest of my practice suffers, and I have to practice law. It's not.
Yeah, no, it makes sense.
It's not cookie cutter law as it usually is for just a regular court trial.
So what's the longest you've seen? We'll take an order. We'll stay in Orange County. What's the longest time you've seen it take to get a tenant out? You personally?
Depends if they get an attorney and they stay the eviction. Foreclosure evictions can take longer, because they can file a lawsuit in the Superior Court, get the case stayed, and they have to pay money during the period of time to the court or to the tenant. I've got a case going right now in Los Angeles from August of 2023. And I'm going to trial on that on Monday, because the other side has been engaged in trial, or just no courts available. It's a zoo up in Los Angeles. So that's why I don't take LA cases anymore.
Well,
I get to drive up there and spend my days up in beautiful Stanley Mosque. But the longest for just a garden variety eviction, it took a year, because they filed 2 bankruptcies, they filed lots of motions, and it took about a year. But that's the exception rather than the rule.
now I'm not sure. You probably won't remember this, and I'm 90% sure I had recommended you to my clients. But I had a gentleman who had his father owned a house in Anaheim, and he was in his 80s, and he had his father was, and he had and it wasn't a nurse, but it was like a nurse. So he just wanted someone to live in the house to keep an eye on him and make sure he'd take his meds, and just in case he fell, for safety reasons. It was a friend of the family, and they never put together a lease agreement. And when he passed, she wouldn't leave. And I think they contacted you, and this was probably a dozen years ago at least. But I guess what I'm getting at, it's very important for a landlord to have things in writing. No handshake deals with friends of the family or anything like that. Would that be fair to say?
Usually is. Samuel Goldwyn of MGM said oral contracts are worth the paper they're written on. And that is exactly the truth. However, what you've talked about is very, very common. And people that move in are employees, basically. And if, say, for instance, in that situation, the father dies, then the kids become the successor trustee, or they're the new owner or administrator of the estate. And all they have to do is fire that person and start an eviction. They're called the tenant sufferance, because they have no landlord-tenant relationship. And you can go ahead and do that. Or if they're considered a tenant at will, meaning that they were given permission to live there and for no rent, then you can give them a 30-day notice and revoke that permission, and then start your eviction after 30 days. But if they're an employee, you fire them and start your eviction. It's just like an apartment manager. If an apartment manager gets the rent as compensation, they are considered tenant at sufferance, and as soon as you fire them, you can start an eviction.
Okay. Hey, now, is there a difference between commercial? Do you handle commercial?
I do handle commercial. Yeah,
Okay.
there is a difference between commercial and residential, a big difference. First of all, in commercial, there is no breach of the warranty of habitability. It is their independent covenants. The lease usually divides up the remedies. And if the landlord was supposed to take care of the roof and the roof leaks, they can't withhold the rent. They can sue the landlord for it because it's the landlord's fault, but the landlord, they still have a duty to pay the rent. There is no breach of warranty of habitability. That defense is taken away. Also, there's no retaliatory eviction. There's only one case in California that they had retaliatory eviction. It was custom parking, and that's where the landlord said to the tenant, I want you to lie, testify on my behalf, and they refused. And then the landlord tried to do an eviction, and public policy says that that would be a retaliatory because they asked them to lie in a court. But there is no retaliatory eviction. They fight harder in commercial because it's their business, and sometimes they're not there, and it takes a little bit longer because you have to do what's called an order to post.
What should landlords do before leasing a property to avoid eviction issues down the road?
That is a great question, and a lot of times landlords they're their own worst enemies. First of all, I just had a case where a landlord let a tenant in, didn't get a rental application, and a rental application is so important because you find out where they work, where their bank account is, what kind of car they have, social security number, but the landlords, a lot of them don't verify. Find out where they work. If they'll put a phone number down, and sometimes they have a friend answer and say, oh yeah, he's employed here. The landlord should take an extra hour and drive over to see where that person works, because there's a lot of people that have been evicted before and they know the game. They put somebody else's address down as their employer, and they have it all set up, and they call up and they verify it. Yeah, he makes $100,000 a year.
Mandalay Industries. Anyway, that's a Seinfeld episode. Go ahead. I'm sorry.
Yeah, man. The puppy sleeves. Yeah. Okay. So, anyways, so that's a big thing. The worst thing that a landlord can do is the tenant says, oh, here's my application I've already prepared. Well, that's a big red flag, because you should have them fill out your own application, because when they give you an application, the landlord goes, oh, look, I'm going to save $25, and they don't verify it. If you don't verify it and you just take their word for it, then you've got a world of hurt coming up down the future. The next thing they should do is they should also check the last landlord and go see where maybe they lived, because I've had people put down that they've never been evicted, and then all of a sudden they pop up again. I call them frequent flyers. And I'm doing an eviction right now where I've evicted this guy 4 times and keep saying, oh, I've never been evicted. So I after all these years, my memory is the second thing to go, but I still remember some of these people, and I just look at their application. I call my client and said, did you get an application from them? They'd say, yeah. Does it say they've never been evicted? They go, yeah. I said, send it over to me, and we'll introduce that as evidence that they lied on their application to get into the property. So they don't check their credit. You need to check their credit. That's really important, because if you don't check their credit, you don't check their license, make sure that they're actually the person that is doing it, or they have an identity theft, you're going to get nailed. So you got to check their social security number, you got to check their credit, you got to check their ID. And
when you say check, you're talking about just show us the social security card.
Yeah, if you can get that, that's great. If you can get a copy of their license, photocopy of their license. If you, instead of saying that you have a bank account, they put down a bank account. So what I do on my rentals, I say, okay, you know what? Can you photocopy the last bank statement you have, so I can make sure you just don't have $1 in there. So you get verification. Ask for a pay stub,
And as of now, it's still okay for landlords to do this.
Oh, absolutely. They haven't taken that right away. But you can't ask if they're a felon anymore. Your governor, Comrade Gruesome, took that away from you.
Amazing. And now I heard that there was another law passed that for application fees, you mentioned $25. I know it'll vary between $25 and $40. That let's say a landlord's leasing out a house and they get 5 applications, they accept one, they process all 5 of them. They actually technically, if the tenant applicant asks for their application fee back, have to pay them back, even though they spent the money. Is that?
I heard something like that. There was some kind of new law that got passed this year. I think they can just check, and if they show proof of the cost of the checking of the what it costs for the
On the credit.
yeah. I think it's that way. I'm not 100% sure on that one, but I heard that law changed too.
All right. Now, what about, let's talk about landlords using property managers. Is that, I don't know, what is my question? Is that advisable in your estimation? Property manager, does that help in any way, shape, or form?
Absolutely. By the way, the other thing that the landlords, the big mistake that the landlords will do, getting back to your last question, is they take a personal check on a move-in. You do not take ever a personal check on a move-in. You get a cashier's check or cash. The reason I say that is how many times I get this landlord that doesn't know what they're doing. This is my first landlord, first time I'm renting. They take a personal check and guess what? That check bounces. And then all of a sudden you have to do it. They're in your property. You don't have a security deposit. You don't have a first month's rent, and you've given away your property, and you're not going to ever see your money. And that's the biggest mistake a landlord will do. Always get certified funds and always get all of it, the rent and the security deposit when you move in. Because if you don't, you're in for a world of hurt. Okay.
Oh, that makes sense. So, well, yeah, what about a management company? That's advisable to have a management company?
Oh, I would think so, because a management company is a professional. They know all this stuff. You're not going to get rookie mistakes. They check on their own credit. The 5 or 6% that the management company charges is well worth it, because they can smell a bad tenant versus a good tenant most of the time if they're a reputable management company, and they do all the checking. It's vet before you put in it. Just like buying real estate, location.
Yeah.
You have to check your people before they move in, check their credit, and 90% of the time you won't get burnt.
Is it fair to say, is there a process too to document any sort of communication with tenants when you're going through things, meaning, maybe emails or you can't record their voice without their permission, if I remember correctly, but you got texts and stuff. Is there an advice that you would give people to say, hey, just do text or just do emails, or is that a non-issue?
It would only become an issue if you have to go to trial. You also don't want to violate privacy laws, and you also want to make sure you don't discriminate based on race, gender, sex, on that, because there's a lot of testers from the fair housing that will go out and check to find out if the landlords are discriminating, and then they'll bring suit against you.
2025, are you seeing more evictions recently than you have in the past?
Yes, I have. And one of the reasons because of that is because of COVID. People have the entitlement mentality. They're saying, I don't have to pay the rent, or it's dissipating the longer we're away from COVID. But after COVID, it was unbelievable how busy it got. And because they said, well, I don't have to pay rent because, we got free money from the state. And it just the entitlement mentality of the tenants. A lot of times, sometimes you got tenants that actually they lose their jobs. It depends on the economy. When the economy gets bad, I get busier. So and the economy right now is not in a wonderful state. So the evictions are up, and it's taking longer to get people out, and the sheriff is not making things easier because they're taking longer. For instance, in Long Beach, they're taking 2 to 3 months to do a lockout. It's ridiculous up there in LA County. Some of the LA County sheriffs are pretty quick, 3 to 4 weeks. But you got Long Beach, you got downtown LA that take a long time. Inglewood sheriff also takes a long time. So it depends. It's taking longer, and there's more evictions.
I tell you, Steve, thank you so much for doing this. You've given such valuable information to our listeners. If somebody did want to engage with you or hire you, what's the best way to contact you?
Well, the best way to contact me to call me, which is my phone number is 714-832-3651. I always return phone calls. I try to make them short and sweet because people want to tell me their life history, and I'm
You're a busy man.
I bought this property 5 years ago, and I said no. I like I said, I direct the conversation so I can get on and off the phone calls because I get so many people that call me, and then they say, "Well, I called you 2 weeks ago." I go, "Well, I don't remember what I had for breakfast this morning, so I don't remember that." So I'll just go through and ask. I'll screen them in regards to their notice if they've done it. And if they want us to do the notice, I will give them to my assistant. We'll send out a questionnaire and a credit card form for a notice or a lawsuit, and we'll start going that way. I have a website, which I have a lot of videos on it, some legal forms on it. My website's my name, StephenDSilverstein.com. And you'll get my webpage, and there's different links you can go to. I have 5 videos on it. I have some articles on it. There's some interesting things on there. And people ask me, "Oh, can you go through the process?" And I say, "No, not over the phone." And I give them my website because I have a video telling them about the eviction process, because I can't spend 100 years on the phone with somebody.
By the way, hopefully this is a fair question, but what's it cost to hire you? Does it depend on?
I charge $385 plus costs. So for instance, an eviction in Orange County under $10,000, if you pay cash or check, with the $385 for me, it'll cost you $1,080 for an uncontested eviction, cash or check. Uncontested means no court appearances. If you pay by credit card, it's $1,120 for an uncontested eviction. That's assuming the rent is below $10,000, because there's a step up with the
a month.
No, there's a step up with the court. If it's over $10,000 that the amount's owed, then the filing fee goes up higher. If it's over $25,000, the filing fee goes up higher. So I always ask how much they owe. Is it under $10,000? That's uncontested. That means no court appearances. For right now, for the end of, to the end of the year, it's $385 if they file an answer, and if they get me from 8:30 to 12 o'clock in Orange County or any portion thereof. I charge a flat rate for a trial. What I try to do is I try to get as many trials in one day as I can to make it profitable for me to go to the courthouse. But if I have one court appearance, it's one court appearance. If I have 6, it's a good day for me.
So, but the overall cost for a landlord would probably be less than $2,000 to go through a process of hiring an attorney, hiring yourself with fees and everything.
Yeah, it would probably be that. If the tenant files frivolous motions to stall the eviction off, that costs more. If
Goes
they
up.
discovery, that costs more. If they file bankruptcy, that costs more. Depending on how hard they make me work, it's what it's going to cost. If it's a simple garden variety eviction, it can be anywhere from $1,080 to maybe $1,500 if it's just a contested matter in Orange County.
Okay, I'm going to let you go. Time is money. You're probably busy. I just can't thank you enough for joining us for this podcast. I sincerely am grateful for you, sir. Thank you.
Thank you very much. And it was a pleasure chatting with you and getting to meet you.
I appreciate it. Bye-bye now. Those of you that have not subscribed yet, please click on that subscribe button. It'll help get this video out to more and more people.